Chair, we are now live.
Thanks very much. Good morning, everybody. It's Thursday, the 10th of November, 2022. This is, we're broadcasting live and recording. This is a meeting of the Licensing Subcommittee of the Royal Borough of Kensington and Chelsea to decide the application for My Sheesh 23 Pembridge Road W11. My name's Greg Hammond. I'm Councillor for Courtfield Ward in South Kensington. I've got no interest to declare, but I am familiar with the location of the applicant's building. I'd like to ask my fellow panel members to introduce themselves, starting with Councillor Wade, please.
I'm Councillor Wade, Earls Court resident and councillor. I do have a declaration. I do live near the DPS. I don't know him, haven't spoken to him, but I do know the location.
Thanks very much indeed. And my second colleague.
Hi, I'm Councillor Laura Burns from Chelsea Riverside. I have no declaration. I am aware of the area and premises though.
Thanks very much. Now, we're through the decision makers in the case, but we're assisted by some other parties in the room, starting with our legal officer.
Good morning, Chair. This is Lindsay Lamazurier.
Thanks very much. And then we have licensing department represented today by.
Good morning, all. Fiona Johnson.
Good morning. And the governance team, with a number of governance officers with us. I won't ask them all to speak, but we've got Anne, Tom, Gareth and Luke, I think, in the or at least they were on the list. I don't know if they're all in the room, but some of them may pop up if we have any administrative issues to deal with. Now, the applicant I don't see in the room. I'd normally ask them to introduce themselves, but we do have responsible authorities here today. So the police, first of all.
Yes, Chair, it's PC and Davis licensing. Thank you very much.
Good morning, PC Davis. And Noise and Nuisance are here.
Good morning, Chair. Winston Labar, Noise and Nuisance.
Good morning, Mr. Labar. And Planning are here.
Good morning, Chair. It's Ashley Wilson from Planning.
Thanks very much. And I think we've got a number of objectors in the room. So I've got Fiona Fleming-Brown.
Good morning, Chair. I'm the Chair of the Pembridge Association, and it's my conservation area that this premises is within.
Good morning. And then I think I heard Mrs. Johnson or Dr. Deal, same person, appear as I was joining the room.
Yes, I'm here.
Thanks very much. And Mr. Andrew, I think.
Yes, I'm here. I'm a local resident.
Thanks very much, Mr. Andrew. And then we have a witness, Councillor Smetterling, as well for the objectors. Who's on mute, but I can see him.
Good morning. Here. Thank you.
Good morning. So I think that's everybody in the room. Ground rules for doing an online hearing. Please do only unmute your microphones when you're called to speak, because otherwise we might get some interference. You're welcome to turn your cameras off when you don't have a speaking part to save bandwidth. And I must tell you, the chat function on Teams is not being monitored, so please don't use it because it's quite distracting and it can't form part of the legal proceedings that we're going through today. Now, in terms of the documentation we've had, I'll just go through that. So we've had the main hearing bundle, which was 102 pages, and the hard copy had the notice of hearing on the front of it. We'll call that Exhibit 1. We then had an email containing an additional, what was said to be an additional email from the police, but it was only the text. There was no email header on it. We'll call that Exhibit 2. And there was a second text of an email, or said to be a text of an email from Noise and Nuisance, which we'll call Exhibit 3. Now, both of them were sent to the parties on the 27th of October at 13:23. And then we had an additional email from Planning, which was dated the 27th of October at 13:37. We'll call that Exhibit 4, and that was sent round to the parties on the 28th of October at 9:10. So those are the four set of documents that the panel has received, and we've read them all, so no need for anybody to read out the contents again, but please do draw our attention to any aspects of them that you wish to. Because this is an online hearing, I'm going to ask my colleagues to elect a substitute chair. The reason for that is that the quorum for doing one of these decision-making hearings is 2, and if my connection happens to drop out, which I think is very unlikely, and I can't get back in quickly, the hearing can proceed So I'd like to nominate Councillor Wade to be the substitute chair. Is that seconded by Councillor Burns?
Yes, I second that.
Okay, and is that agreed?
Yeah.
It's agreed. I see that. Okay. Now, just before we get into the meat of the subject, I see the applicant isn't here. Could we work out whether we've given the applicant reasonable notice? So perhaps I can ask Anne to read out what efforts you've made to inform them of the meetings taking place today.
Yes, good morning. Certainly, Chair. I'll just run through the dates with you if that's helpful. On Wednesday, the 26th of October, the notification of hearing was sent to all interested parties, obviously including the applicant. Then on Thursday, the 27th of October, a full hard copy of the notification and the report were posted first class to the applicant. On Thursday, the 27th of October as well, an email was sent to all interested parties, including extra comments from the police and noise and nuisance. On Friday, the 28th, an email was sent to all interested parties to include the comments from planning. Then on Monday, the 7th of October, an email was sent directly to the applicant asking him to confirm his attendance. On Tuesday, the 8th of October, I called him personally and I left a voicemail for him asking if he would like any help attending, if we could assist him, if he didn't have access to a computer, if he would like us to contact him via the phone for the meeting. And then on Wednesday, the 9th of October, that was yesterday, we sent the draft conditions were sent to all the interested parties. So a number of attempts have been made.
Thanks very much. I'm going to ask my two colleagues if they agree with me that reasonable attempts have been made to give to serve the notice of the meeting. Councillor Wade, would you agree with that? You're on mute, but I'm seeing a nodding head. Councillor Burns, would you agree?
I agree. Yeah.
Thanks very much. So I think we can take notice as being duly served, but proceeding in absence, Ms. Le Mesurier, perhaps you can advise us on whether we can legally proceed in absence.
Thank you, Chair. I just wanted to clarify one thing quickly. Anne was referring to October when she meant November a few times in her list. So when she said 7th of October, she meant 7th of November, 8th of November, 9th of November. So that's just one little point. In terms of proceeding, Regulation 20 of the Licensing Act 2003 hearing regulations provides that where a party has been notified of the hearing and they haven't indicated whether they're going to turn up or if they fail to turn up or be represented at the hearing, then the authority, where it considers it to be necessary, can either adjourn in the public interest or they can hold the hearing in the party's absence. And if they do decide to hold the hearing in the party's absence, particularly where reasonable notice has been given, they shall consider any representations made by the applicant, which in this case would be the operating schedule and the application, because I don't think there's been any subsequent submissions from the applicant. So the committee may proceed with the hearing if they so decide. Thank you.
Thanks very much. My view would be to proceed, but I'm going to ask my colleagues if they agree with that view.
Agree.
Agreed, both. So the committee has decided that we will proceed in the absence of the applicant for the reasons set out by the legal advisor. So in a moment, I'm going to ask Ms. Johnson to set out the outline of the case. And then in the absence of the applicant making the case for themselves, I'll ask the responsible authorities in turn to make their statements. Each of them will have up to 10 minutes to do that. And then there'll be an opportunity for questions by members of the committee, by the other responsible authorities, and by the other parties in the room who are all objectors. Once we've been through the three responsible authorities, I'll give each of the objectors in turn 10 minutes to make their case, and the witness for the objectors as well, and then we'll have a joint question session for all of you, for us to ask questions of you. We'll then go through any potential conditions. for the application, which the legal officer will lead. That'll be without prejudice to the committee's decision, but it's important we do go through potential conditions. We won't be doing any summing up at the end of it, and the decision will be issued in writing within 5 working days. So there won't be a recall later on today to announce the decision. So, in the absence of any other preliminary matters, I'll just pause for a moment to see if any parties have any other preliminary matters. Please put your electronic hands up if you do. And nobody is, so I'm going to ask Ms. Johnson, please, to outline the case.
Thank you, Chair. Today's application has been submitted by Mr. Ugo Tasley for the grant of a premises licence at My Sheesh, 23 Pembridge Road, London, W11 3HG. The application before us today was originally submitted in November 2019 and was scheduled to be heard by the Licensing Subcommittee in January 2020. It was adjourned at the applicant's request as the proposed hours were contrary to the planning permission. At the time, Mr. Tasley indicated his intention to apply to the planning department to vary the planning conditions. However, to date, no application has been made. Like the majority of licensed premises, the business was required to close for an extended period of time between March 2020 and May 2021 due to the coronavirus pandemic. The licensing team has attempted to contact Mr. Tasley on several occasions during the past 18 months by telephone, email and letter to establish whether he wished to pursue this application. However, all attempts have failed and we've had no communication with Mr. Tasley since January 2020. A premises licence currently exists at the premises and was granted on the 14th of June 2019. The licence currently permits the sale of alcohol for consumption on the premises on Monday to Saturday from 11 AM until 11 PM and on Sunday from 11 AM until 10:30 PM, with closure 30 minutes later. As mentioned in the committee report, we understand from local residents that the landlord has recently repossessed the premises and we are awaiting a response from the solicitor acting on behalf of the landlord to see whether they intend to apply to transfer the existing licence. However, it should be noted that variation applications cannot be transferred. I can confirm that the application was properly made and advertised in November 2019, so cannot be disposed of without consideration by the licensing subcommittee. Moving on to the application itself, the application seeks to vary the premises licence by extending the hours for the sale of alcohol and to include the provision of late night refreshment for consumption both on the premises and for takeaways. A table confirming the new hours sought has been included at page 2 of the report. A copy of the premises licence has been attached at Appendix A, pages 12 to 19, with a copy of the variation application attached as Appendix B, which are on pages 20 to 42. The application has attracted representations from the Metropolitan Police, the Council's Noise Team and the Planning Department. Copies of these representations have been included at Appendix C, D and E and can be found on pages 43 to 62. The licensing team has also received an additional 7 representations opposing this application. A summary of these representations can be found on pages 7 to 9 of the committee report, with copies attached to Appendix F, which is on pages 59 to 75. Council records indicate that the premises received no noise complaints in the preceding 24-month period. Our records also indicate that no temporary event notices have been submitted within the preceding 24 months. In determining this application, the committee must have regard to the representations and take such the following steps as it considers necessary for the promotion of the licensing objectives. So the decision you have before you today is either grant the application in full, modify the conditions of the licence volunteered by the applicant in the operating schedule, or reject the whole or part of the application. However, I would just like to remind the committee that there's been a 3-year time lapse between the submission of the application and the committee hearing. Mr. Tasley may no longer occupy the premises. The annual licence fee has been paid, so there is a valid licence at the premises, and no correspondence has been received from Mr. Tasley since January 2020. That concludes the summary of this application. Thank you, Chair. Thank you, Chair.
Thank you very much, Ms Johnson. Well, in the absence of the applicant being here to make their case, we move straight on to the responsible authorities. And I'm going to start with PC Davis, please, from the police, and give you 10 minutes to outline your case, please.
Yes, thank you very much, Chair. I'd just like to refer to the current police position that's been referenced in my representation. In summary, there are still current concerns in relation to this application, especially surrounding the midnight policy. And further, with inspections of the premises at the time, there were subsequent breaches identified, and a closure notice was issued to Mr. Tasley at the time. However, they were remedied, but there is an overall concern around the public nuisance objective around management of the couriers in that locality. I refer to page 48 in the bundle, which is a photograph that I took of outside the premises of the double yellow lines, and as a prime example of my humble opinion, the sensitive nature around managing couriers outside these premises and issues around the Road Traffic Act and the nuisance caused. It's a very busy thoroughfare with buses and public transport, etc., that run throughout the day and the evening. According to our records, I did a search on our integrated intelligence platform, which is a database going back to the 9th of the 5th, 19. There's no issues in relation to the premises. However, on the 19th of the 8th, 22 at 05:30, we had a call via the bailiffs who attended the premises to repossess the property on behalf of the landlord. We understand for non-payment of rent. There were a few persons inside the premises who were allowed to leave at the time. So just to summary the police position, as being over 3 years, and owing to the time lapse and circumstances, we would ask the committee to outright refuse this application, and the landlord, whoever's going to be managing or running the premises, to resubmit in good time, as it's quite clear that we're not going to know who's running the premises and how they're going to run. That is the police submission. Thank you very much.
Thanks very much, Constable Davis. Did you use the phrase that the current timings are what you regard as the optimum for the area, or was that noise and nuisance?
No, that's my phrase.
Yes, I thought it was. I recognised the phrase as being a police phrase. Can you describe what you mean by the optimum hours for the location, particularly in reference to this case?
Yeah, in my opinion and experience, in support of the midnight policies, that the license operating on the times is sufficient, and any extension would exacerbate primarily the public nuisance objective. It is quite a sensitive location through experience, and there's a lot of residents that are local that be hampered by extended hours. And
of course, the current license it doesn't quite go up to midnight. So would you say that an extension to the midnight policy would sort of breach your view that the current timings are the optimum?
I would say that if the committee were minded, it would be any extension would be within the midnight policy. But that would be also your discretion, Chair.
Thank you. So I'm just taking a note. Let me ask my two colleagues if they've got any questions for you. I'm going to start with Councillor Wade, please.
Good morning, Mr. Davis. I'm looking at your picture of the motorbike on the double yellow line. Close to that location, is there alternative area for delivery bikes to park?
Not really. Well, I mean, it's a debatable issue. It's into park. Obviously, there's no facility for parking there. There's Ken Park Road or in Portobello Road, but with the business model of a lot of businesses, as the council would be aware, especially around the Earls Court area and the borough and I think Met Wide, they will park and do whatever they want, whenever they want, however they want, to make it easier for them to facilitate their business. And there's almost like a stepped pavement there. So, and as I said, there's pedestrians. It is a busy thoroughfare. So, I hope that answers the question, Councillor.
And you said that it's not going to be clear who will run the premises. So, do we know what has happened to the present DPS? So, for example, if the license was granted in this particular form, it would appear to be granted to this particular DPS, wouldn't it?
Well, it does, and that is the primary concern. There's no representation of them, no attendance, I should, in relation to this hearing. And I understand there's been extensive efforts to contact any and all individuals, and no one's here, so we can't really question or speak to any representative. So I think it would be a bit of a concern to issue a license in these current circumstances.
And so I've looked through the paperwork, and so you've there's the issue of hours, but you mentioned breaches. How serious were the breaches?
There are breaches in relation to signage. I mean, the proportionality, the more administrative. A closure notice was issued, but from my experience, it's just an example of poor management at the time during that inspection. Summarily, they were addressed in time. However, one would expect, especially within the Royal Borough, that around applications that they're operating should be in tip-top condition. But there was obviously concerns. But as I said, they were remedied.
So would you say this is a case of reactive management rather than proactive management?
I agree, yes.
All right, thank you.
Thanks, Councillor Wade. Let me ask Councillor Burns if she has any questions.
Some of them were just answered, but one would be, I know you said that they were called to the that you were called to the premises for a bailiff situation. Has there been any others during the jurisdiction of the current management, as it would be?
No, as I said, there's not anything significant. I mean, there was a burglary. It's not in relation to the operation of the actual venue and the license. So in context, bar the bailiffs attending in the last since the 9th, 5th, 19, there's been nothing of issue.
And just sort of any neighbouring restaurants or things that are actually open for the later hours that they're requesting. What is your, because obviously they're in a local area, do you see more crime or issues or noise nuisance or complaints, or does it not really? How does that correlate locally?
I think the police position in relation to this application is all around the management of couriers at that location, and obviously the pedestrian and the nuisance aspects and around breaches on the Road Traffic Act. And it would be, how can I say, particularly difficult, if not inconceivable, for them to actually have a delivery mechanism at that location. Based on my experience, a lot of other courier companies are in more sort of more industrialised sort of areas, less residents. I think it could be impacted if this was to be granted beyond midnight.
But they currently, maybe not currently, but they previously have had delivery services, right? And so, have there been many complaints with the?
No, not on our records.
Okay, right, that's it.
Thanks very much, Councillor Burns. Now, before I proceed with questions from the legal officer and other parties, I've got Anne Wright's hand up as one of the governance officers.
Yes, thank you, Chair. Just to say that I think there's been some difficulty in everyone hearing PC Davis. So if you wouldn't mind just either speaking closer to the microphone or turning his volume up, that would be helpful.
Is that better?
No.
No? Is that better now?
I think I'm certainly I've heard everything that PC Davis has said. I don't know if my panelists have heard. Let's proceed with how it is and ask Ms. Merzier if she's got any questions for PC Davis.
No questions from me, Chair.
Thanks very much. I'm going through the other responsible authorities. Mr. Labar, any questions for PC Davis?
None from me, Chair.
Thanks, Ms. Wilson.
None from me, Chair.
Thanks very much. Now I'm turning to the objector parties. So, Ms. Fleming-Brown, actually, are you Mrs. Fleming-Brown or Miss Fleming-Brown? I don't want to be discourteous.
I'm Mrs. Fleming-Brown, but I'm very relaxed about however you charge me.
Fantastic. Thanks very much. Do you have any questions for PC Davis?
No.
Questions?
No, I think he's given a very clear description of the area, and when I come to make my statement, I will expand on that. Thank you.
Thank you very much. And Mrs. Johnson or Dr. Deal, which do you prefer?
I honestly don't mind. I think my objection was under Mrs. Johnson, so it's probably easiest to stick with that.
Probably is. Do you have any questions for Constable Davis?
No, I don't.
Thanks very much. And Mr. Andrew, do you have any questions for Constable Davis?
No, I don't. Thank you.
Thanks very much indeed. Right, so PC Davis, that's the end of your evidence session, and we're now moving on to Mr. Labar from the Council's Noise and Nuisance team. So I'll give you up to 10 minutes to make your case, and then you'll have a question session.
Thank you, Chair. Yeah, my representation in 2019 still stands, in as much as I believe this application is wholly inappropriate for the vicinity, location and times applied for. One point I'd like to make is that this application was made in 2019 and the situation 3 years has elapsed since then. Situation and times and can I say has changed since then, and for us to be looking at an application that is 3 years old to me isn't really something that we should be doing, and I believe that the applicant should be reapplying, looking at the situation as it is today and not 3 years ago, as things changed and the situation moves on. Having said that, the original representation that I made in relation to them not promoting the licensing objectives with regard to the promotion of public nuisance still stand, in that their application does not provide any evidence to promote the licensing objectives, i.e. that they were going to, can I say, promote the 4 licensing objectives, especially one with regard to public nuisance, but others obviously as well regarding to crime and disorder and health, public safety, etc. But most permanently for my situation, the public nuisance objective. As my colleagues in other who have made other representation have alluded to, the terminal hour at the moment, I believe, is 11 o'clock and 10:30 on a Sunday, and to try to can I say extend that to 4 in the morning and 5 in the morning for on and off sales and opening hours is entirely inappropriate, in as much as the area is mostly residential. The pavement outside the venue is extremely narrow with double yellow lines along its length, and the road itself is incredibly quiet at night, especially with the background noise levels are greatly reduced. Any kind of parking or deliveries at that time would give rise to public nuisance, in my view. Plus, there's nowhere for them to park. You know, it would cause disruption to the traffic and so on and so forth. So that's another reason why I believe that the application is entirely inappropriate and that the terminal hour they have now is suitable. The other thing is that they don't have planning permission to extend till 4 or 5 in the morning. So I don't understand how they can apply for something which they don't have planning permission for. And that needs to be taken into consideration because it's of great importance with regard to this application. Litter patrols and things like that should be increased if this application were to be successful, and also patrols throughout the day to ensure that they are promoting the licensing objectives. But I don't think I would request that the committee refuse this application because A, it's out of date, it's not current, and for the reasons that I've set out, that it will not be promoting the licensing objectives with regard to public nuisance. I've finished my representation, Chair.
Thank you very much, Mr. Labar. So I think that's very clear that your pitch to us is for an outright refusal. But what do you say about the application of the midnight policy? Just expand on that, please, because the current terminal hour is before midnight.
Again, if the applicant would like to go to midnight, I have no objections to that, providing they can demonstrate to us how they will be promoting the licensing objectives. The application that they submitted in 2009, apart from being way out of date, does not promote those objectives. So I cannot, in true, sort of merit, take this application to go to midnight unless they can demonstrate to us that they are going to promote those licensing objectives, because that's, that is part and parcel of what this application should be doing. And if they're not doing that for the application in 2019, then I think it's wholly inappropriate for us to change anything that they currently have.
Thank you, Mr. Labar. Let me turn to my colleagues, see what questions, if any, they've got. Councillor Wade first, please.
I think I don't really think that I need to ask any questions. Thank you.
Thanks very much, Councillor Burns.
Yeah, similarly, I think we got all the information from.
Thank you very much. That's the panel questions. Ms. Le Mesurier?
No questions from me, Chair.
Okay, I'll just run through the responsible authorities. PC Davis, anything from you?
No questions from me, Chair.
Thanks very much. Ms. Wilson?
No, none from me.
Okay, going to the objectors, Mrs. Fleming-Brown?
No, nothing from me.
Thanks very much. Mrs. Johnson?
No, nothing from me.
Thanks very much. Mr. Andrew?
Nothing from me.
Thanks very much, Mr. Labar. That's the end of your evidence session. Thank you very much indeed. I'm now going to move on to planning, and Ashley Wilson, please. You've got 10 minutes to make your opening statement.
Thank you, Chair. So really just a bit of planning background. In 2016, the operator received a prior approval. So it's not a planning application. It's always can submit some details, and it was approved for change of use from retail to restaurant with associated development. And condition 5 of that permission stated that the use shouldn't be carried out other than between 0800 and 11 on Monday to Saturday and 9 AM to 23, so 11 PM on Sundays. So that's 11 PM every night. Further to this, there was a condition that stated that the kitchen extract system couldn't be used after 11 PM every day. So I think the idea of that was also to reduce noise disturbance to residents. Early 2019, I advised the architect on behalf of the owner about the planning conditions, and they do have the opportunity to vary the condition, but it's unlikely to be approved. My case was left open for a few months, and to date, there's been no applications to vary the condition of being sought or granted. Similarly, no applications for planning advice. There's been no communication. It's a mixed use area. It's quite commercial at ground floor level. retail, cafe, food shops, and there's offices, residential, the first floor level, to the rear, to the front. I also question if such a late night refreshment terminal hour would change the planning use to a hot food takeaway, rather than the permitted use, which is a restaurant who primarily sit-in sales. I don't know if many restaurants are open till 4 or 5 a.m. Many people want to dine. I think it would most likely change the use to a takeaway, which, regardless of the hours, the use of a takeaway here is probably unlikely to be approved for planning permission. It probably involves a lot more harms than the later hours. So in conclusion, these later hours are in breach of the planning condition. It would be contrary to our local plan policy CL5 for living conditions, and it might produce an additional breach of planning control for a change of use. So that concludes my representation.
Thank you very much, Ms Wilson. So let me just clarify that the current licensable hours are the maximum permitted within the planning permission. Is that right? Is that my understanding correct?
Yes.
Thanks very much. And just my question, legal question to Mr Mazirier, to confirm that planning and licensing operate completely separately. So the applicant in law we can grant a license to whatever time we think is appropriate. But if the applicant can't get planning permission, they can't do the activity anyway. Is that my understanding correct?
That is correct, and the licensing guidance advises that we shouldn't seek to replicate provisions from other legislation. So you can go ahead and grant a license if you like. But obviously, they will be in breach of planning control unless they sought the appropriate variation application.
Thanks very much. OK, let me ask my colleagues if they've got any questions for and Councillor Wade first.
Good morning. Yes, I have a couple of questions, and I think you've confirmed one. Is the area above the premises residential, or is it an office? Do you happen to know what the usage is?
I think it's residential.
And I noticed from looking at that wonderful thing called Google that actually the rear, which is where the kitchen extract would be, is very close to properties in Kensington Park Road. And therefore, presumably, that was one of the reasons why there was this restriction placed on the kitchen extract system or hours of operation.
I agree. It's quite rare that we would then attach an additional condition for the kitchen extract system. Usually you just see the hours of operation, but I think it must be because of the proximity.
Because I think looking at it, you've got the only place that you could put the extract would be at the rear of the venue, which is presumably, just looking at it on plan, is very close to, because it's in a V shape, that actually it's very close to the rear of properties in Kensington Park Road. I mean, I just find that very interesting to see that clause in a planning letter. So thank you. I think that should be noted, Chair.
Yes, any comments from planning, as this is a question session?
Yes, it wasn't a full planning application. So at the time, there was kind of, you didn't require full planning permission, but it was a prior approval. So subject to certain criteria, the operator would submit details of noise mitigation measures, traffic mitigation measures, so the council could agree that it was acceptable in principle rather than a full application. It was I think it was an attempt to free up and loosen the use class order so that there was more flexibility in changing use classes. Now it's being relaxed so that the change would not require planning permission, but I think at the time in 2016 this was kind of a half measure of not a full planning application. So I think we had to be, at the time, based on the legislation afforded to us, we had to be a bit more not relaxed, but we had to attach these conditions to be able to confirm that this could be here.
Thank you. Councillor Wade, did you have any supplementary to that? No, thank you very much. Councillor Burns, any questions from you? You're on mute.
I guess just a follow up on that really. How easy would it be to get a planning permission sort of extension for hours if we were to grant extra hours here?
It's quite a straightforward application to apply for. Based on the proposed term hours of 4 and 5 a.m. I think it would be unlikely to be approved. I think there'd be a lot of public opposition. I think it wouldn't even get to a planning committee stage because we could refuse it under delegated authority, because I'll check the planning history of the area and I couldn't find anywhere else around where we have granted such late hours. A lot of places, it's a very commercial area and it's very established, and there isn't many planning applications in the area where we can attach these conditions for a change of use, but where we have, it's never been 4, 5 a.m. So I think it would be very unlikely to be refused based on our local plan policy CL5, which requires all development to ensure good living conditions for occupants of neighbouring buildings.
Okay, thank you.
Thanks very much indeed, Councillor Burns. Now, Mr. Missouri, any questions for planning from you?
No questions from me, thank you.
Thanks very much. And the objectors, Mrs. Fleming-Brown, any questions from you?
No, nothing from me, thank you.
Thanks very much, Mrs. Johnson.
Nothing from me.
Thanks very much, Mr. Andrew.
Nothing from me.
Thanks very much indeed. So, Ms. Wilson, thank you very much. That's the end of your evidence session and the end of the responsible authorities pitches to us. So I'm now going to turn to the objectors in turn and give you the three of you. In fact, I'm going to give the three of you 10 minutes each, and Councillor Schmetterling 10 minutes as a witness as well. You don't have to use all 10 minutes each, of course. And once we've got to the end of the four of you, we'll ask questions. So I'm going to start with Mrs. Fleming-Brown, please.
Okay. Good morning. I'm Fiona Fleming-Brown and I'm the chair of the Pembridge Association. So I represent residents in the Pembridge conservation area, and the premises is within this conservation area. Now, this section of Pembridge Road mixes small independent retailers at a ground floor level with residential use above. And there are also some very adjacent properties such as Bulmer Mews, which are completely residential. There's no commercial activity there. And as Councillor Wade said, Kensington Pot Road is also very proximate, and it's the residential section of it. So the area in which my sheesh is located has a sort of village-like atmosphere. The properties are very low rise, and what that means is that the houses are very proximate to street level. These aren't large, high-ceilinged premises. And it's an area which is interestingly becoming progressively more residential and more densely occupied. So it used to be much more transient in character, with more young people, perhaps students, coming and going. That's changing. It's become progressively more residential, and a number of commercial properties, such as the dentist, are now given over to residential use. So it has changed. And the unusual thing about it, as the police commented, is that it has a relatively high and narrow pavement. Further down Pembridge Road, it's actually a double step pavement. And it is quite hazardous because it means that on the Saturday drag to Portobello Road, which many tourists take, if there's any obstruction to the pavement at all, it becomes quite a dangerous footway. And in fact, there has been a recorded injury of somebody being pushed off the pavement and suffering an injury. It's not somewhere where you can have queues, and it's not somewhere where you really want to see groups of people coalescing to perhaps eat their takeaway outside the premises. I'm particularly concerned about groups of people or delivery staff collecting takeaways outside the premises, because I think it shows that there is a public safety and a public nuisance issue there. I was concerned to see clause 31 proposed, which envisaged a delivery service would need a policy, I would say that this area is completely unsuitable for bikes or motorbikes, as there's no suitable parking adjacent to it. The nearest place that could be used would be the bike area on Pembridge Square, which is again a very quiet residential area. There's a characterisation of Pembridge, this section of Pembridge Road and Portobello Road, as a sort of very lively thoroughfare. It's a paradox that that's true, but at night time it is very, very quiet. And that's because most of the other users of those premises are small shops selling antiques or tourist souvenirs. So the noise level drops dramatically. So motorbikes revving, delivery drivers chatting would be a real nuisance. I think the police summarised the hazards of parking adjacent to this area very well. So we would suggest that if takeaway licence of any sort was to be agreed, and we would rather it wasn't, it would be restricted solely to customers arriving on foot. And this shouldn't happen later than 10 p.m. We're concerned that nearby streets in the conservation area, which are very quiet at night, such as Bulmer Mews, would be the places that people would then take their very late night takeaways to consume. These areas have a history of attracting antisocial behaviour, so this isn't an idle comment. This is based on complaints which residents have made. We urge that there is no extension of hours from those granted in June 19, which is Monday to Saturday, 11 to 11, and on Sunday, 11 to 10:30 p.m, which seems to strike a good balance between commercial interests and those of residents. But I think that extending takeaway hours until 4 a.m, Sunday to Thursday, and until 5 a.m is far too lax. We would therefore ask these variations to be refused. Thank you.
Thank you very much, Mrs. Fleming-Brown. Let me ask Mrs. Johnson to take the stand for 10 minutes, if you wish to use the whole 10 minutes.
Thank you. I'm certainly not going to use the whole 10 minutes. I would completely second everything that Mrs. Fleming-Brown has said. I'm a resident of Bulmer Mews, so I can attest to the problems that we have had of people using the mews to eat their takeaways and indulge in very antisocial behaviour, which was blissfully quiet during the period of COVID lockdown, but is starting to happen again, unfortunately. I would also reiterate the concerns about takeaway bikes and drivers. That stretch of Pembridge Road, a lot of the little shops, unfortunately, a lot of them increasingly have turned into food and beverage outlets. And though Maishish, Arancina and the fish and chip shop are probably the key culprits in terms of takeaways, the potential for litter and antisocial behaviour is going up. But the delivery drivers are a major concern. They park not only on the double yellow lines, but also on the pavement. They obstruct. It's an incredibly busy road with buses. And I've watched as delivery drivers have parked there. The buses can't park. The ambulances can't get through. So any thought that the ability to do takeaways would be increased fills me with horror. And I would urge the committee to reject this application and just keep things as they are at the moment. Thank you.
Thank you very much indeed. Let me ask Mr. Andrew to give us his views, please.
So a lot of the points have already been made that I was going to talk about. So I'm a resident on Pembridge Road, so I have first-hand experience of the character. I'm familiar with the issues of the existing 5 shops which already have Deliveroo or Uber Eats, etc., servicing them. So the points that the previous speaker was making are a regular issue. So allowing another premise to start offering or servicing delivery services would just further compound the issue. The other point I would highlight is that the locale of Pembridge Road, north of the roundabout junction with Kensington Park Road, is very different from that south of the mini roundabout. So south of the mini roundabout is far more commercial, and you'd be difficult to argue against extending the hours for a takeaway service in that locale. But north of the roundabout becomes much more mixed residential, and having a service operating to 4 a.m. when not even the pub, the Sun and Splendour on the corner, has anywhere near those operating hours and is much more professionally run, would be a significant nuisance to residents on Pembridge Road. So even if the applicant seemed to still be operating, then we'd have severe concerns about the extension of the hours and the precedent that might set for other outlets changing hands in the future, and they would then be able to lean on the previous application and the precedent that had been set. So strongly object to the change in hours.
Thank you very much, Mr. Andrew. I'm now going to ask Councillor Schmetterling as the witness for the objectors to speak for up to 10 minutes as Councillor for Pembridge Ward.
Thank you, Chair. I'm really here to provide general background to help the subcommittee make up its mind, rather than be a direct objector to this. In fact, much of the discussion, in my view, is moot. PC Davis has actually listed one or two of the key points, which sort of headline what I want to say. My Sheesh has gone. My Sheesh went ages ago, and there was another restaurant operating there called La Yang, which did not need the license, which is why there was no transfer or anything. They were not serving alcohol. I did go to speak to them to try and understand what is going on. I tried to contact Mr. Tusty myself. All these details are not so important. A lot of it's been, in fact, said by licensing, who have made their own efforts, probably more than I have. I've tried to find the freeholder or head lessor. It's not clear who owns the property. If you go to Companies House, you find two of them. And again, for this purpose, it's not so important. But what is important is to understand the background to this. And actually, the premises closed because of there was a problem between, that's La Yang closed. There was a problem between, well, I'll say the freeholder or the lessor, between the head lessor or freeholder and Mr. Tasley, unfortunately, and which led to the freeholder or the owner wanting to repossess property within the premises, which is why we saw the initial notices up there. And La Yang last August decided to leave. They tried to help, but it was too much, and they're not a big business. So actually, as I said, this application is moot. I think it had to come to committee because it's been sitting on the list for almost 3 years, since December 2019. There is no licensee to contact. He's gone, appears. He hasn't. Other people tried to contact him too and failed. So it's a very sad case. I was looking forward to having a Malaysian, the La Yang, a Malaysian restaurant there because I like the food, but unfortunately it's gone. And I think that, well, that's the background, and it doesn't matter what we think, whether it's good or not. And I agree with all the comments about the traffic. This is a problem all around. Tiny street, delivery vans and other vans and motorbikes parked there on the road when there's no space at all. But that's a bigger question, not for today. And on the planning side, yes, I think there was issue of smells and noise emanating from the kitchen, which is why planning gave the hours it did. I wasn't there at the time, but I think that's the background. And I think that is it. So in summary, the license might be live, the original license might be live, but the premises have gone, La Yang have gone, and I think nobody knows what's going to happen to it next. So nobody's going to want the variation. And there's a question what will happen to the original license. But if it's paid up, I guess the freeholder might have it, who knows? Thank you.
Thanks very much indeed, Councillor Schmetterling. And my summary of all three objectors and the witnesses that your pitch to us is for an outright refusal. And if I've got that wrong, you can come back in presently. Councillor Wade, any questions from you for the objectors?
Yes, yes, sorry. It was in Bulmer Mews, when it was operational, did you have to call the police or due to the antisocial behaviour or crime disorder? It's been commented on in the letters of objection. I just wondered whether you had to. It was to a degree, or that you had to call the police, or was it the litter problem that was the problem?
To my knowledge, certainly I and none of my fellow residents have ever had the time to call the police. Usually, the results of antisocial behaviour are visible. The litter, urination, and even more disgusting things have happened within the mews. If we have found people in the mews, sometimes when you come back late at night, there will be people in the mews sitting there eating their takeaways. We usually, well, I certainly would usually ask them to leave. Some leave voluntarily, some leave after being very abusive, but on the whole, I'm afraid to say that calling the police usually takes half an hour to get through to somebody, by which stage the situation has passed. But it's frightening. We have families with young children in the mews. So coming home to find people, the worse for wear, eating their takeaways, I know some of my neighbours will avoid confronting them and will just go indoors and lock their doors.
All right, I've got one more question. If you have three, just because we have got to ask this question, you've got three potential takeaways. How do you know that they come from this takeaway?
We don't know.
But it's just the presence of takeaways.
Yes.
All right. So therefore, you're saying that if there was because of the existing problem, that if there was an extension until 4 o'clock, it would make the situation worse?
I believe so, yes.
All right. Thank you.
Thanks very much, Councillor Wade. Councillor Burns, any questions for you from you for the objectors?
With regard to the delivery going into the mews, do they hang out there as well, or are they just blocking the main road? Just really.
There are now a huge number surrounding us who do takeaways, and we get the delivery bikes parking in the entrance to the mews. So those, I have to say, are more likely to be the delivery bikes for Uli and Portobello, rather than along Pembridge Road where my sheesh is. I would say there is a bike parking area outside the Kensington Temple, which is where we have asked the delivery bikes to park, but sadly, these young men on their bikes are obviously so unfit that crossing the road is just too much for them. So the situation for my sheesh or whatever replaces it, even if you were to point out where they can park their bikes, they are going to continue to park on double yellow lines by a pedestrian crossing, causing an obstruction to the traffic, in my experience.
That's all for me. Thank you.
Thanks very much indeed. Mrs. Fleming-Brown, I think your camera came on in the middle of that. Did you want to add a point to Mrs. Johnson, or or was that just a technical thing?
I think I would say that my experience, because I live very adjacent to Kensington Park Road, is that large groups of Deliveroo drivers do make a tremendous noise. They don't park neatly, and they do have a lot of chat between themselves because there's often long gaps between one delivery and another. So it's very easy for an area to become absolutely colonized by bikes. And a lot of these people are on minimum wages. They have very tough algorithms to beat. They don't worry about where they're parking. They worry about the speed of delivery if they're fighting an algorithm. If they're not, they stand around and chat. That may involve smoking. It may involve music. It may involve themselves eating and leaving rubbish around. But a concentration of takeaways does lead to these sorts of problems. And the more takeaways you have in an area, then there's a multiplier effect there.
Thank you very much indeed. I think that's the end of members' questions. Let me ask Ms. Maziria if she has any questions for the objectors.
No questions from me, Chair.
That's the responsible authorities. PC Davis.
No questions, thank you much, Chair.
Thanks. Mr. Labar.
No questions from me, Chair.
Ms. Wilson.
None from me, thank you.
Thanks very much, and may I just thank all the objectors for taking the trouble to come today to speak to us. That's the end of your evidence session. We now need to go through the potential conditions, which is something the legal officer will lead. This discussion is without prejudice to the committee's decision on granting or refusing, but while we're in public session, we do have to go through the potential conditions to help inform the panel's decision if we get to this stage later on. So, Mr. Maziria, over to you, please.
Thank you, Chair. Obviously, this is a variation application, so obviously we can only add conditions or vary conditions that are proportionate to the actual application. So I'm not proposing to radically alter any of the existing conditions. I just thought that if the council were minded to grant this application, then a more up-to-date CCTV condition should apply. So I've put in alternative wording. If anybody has any queries or wishes to make any points while I'm going through the conditions, please pipe up and then we can make notes.
Thanks, Lindsay. It is quite difficult. Yeah, I was just saying it's quite difficult doing this without the applicant here, because most of the time this discussion is about what's achievable with the applicant. I'll make that point for everybody here, but I think you were about to make the same point and I interrupted you. Please do carry on.
Thank you. Okay, so if anybody has any queries, please just pipe up and as we go through. So I'll assume that replacement condition 9 is acceptable to everyone. Right, if we move on to the noise and nuisance conditions, I've just slightly tweaked the suggested wording, so 29 and 30, just to kind of make it more licensing wording. So 29 and 30, and if anybody's got anything to say, I'll assume they're okay. And then I've added these additional conditions on the basis that if the committee were minded to grant the late night refreshment to try and mitigate any of the issues that arose. So if there is going to be a delivery service, then we would obviously try and have some kind of policy in place. I know that one of the objectors said that they'd rather there wasn't Deliveroo, but obviously we can't necessarily prevent that from happening. So we need to mitigate circumstances. So I'm proposing condition 31 to have a Deliveroo policy, unless anybody's got any comments on that.
Yeah, let me bring in Councillor Wade, had her hand up.
All right. I don't know whether it's possible. I was trying to talk to 29 about the introduction of washing outside the frontage of the premises.
Washing the footway.
The footway, because if you have food waste, I mean, I think it's wonderful to have the waste, the litter patrol. But I think that it's also about actually about how the frontage is kept. Can we get washing the pavement, and in this, can we control how they dispose of their waste?
Yeah,
because it's because it's where they leave their waste with oily waste in it that actually requires routine and regular waste washing of the pavement.
Okay, that seems like a good idea. I'm just having a quick look at the existing conditions. There doesn't seem to be an existing condition which covers that, so we can potentially add in wording to wash the footway down as well. So I'll make a note of that. Thank you.
And that's a really good point. And obviously we can draft one of those. But if we, as a committee, decide on an outright refusal, am I right in thinking that we can't change the current licence to introduce these conditions? So this is really conditional on our making a grant. Yeah. Right. Okay. Thanks. Well, let's carry on going through the. You got to 31 and see what else you want to talk about.
So condition 31 was about the Deliveroo. Condition 32, basically, if customers are going to be, or the couriers are going to be smoking, then to obviously provide smoking bins. 33, customers permitted to temporarily leave and then re-enter the premises can't take drinks or glass containers. I think there's a previous condition which prevents alcohol being taken outside, but this would just cover drinks and glass containers. Number 34 is one of our standard conditions to display the DPS telephone number. So if there's any complaints, that's quite normal. I've also added 35 and 36, which is a record of complaints and how long they're kept for and how they're accessed. And then 37 is one of our standard conditions whereby residents meetings, so to be held twice a year and invite local residents and ward councillors, etc. So any issues can be raised. So that's quite a standard condition. Unless anybody's got any other conditions which they think ought to be added if the committee were minded to grant, I think that's it.
Okay, I'm just going to pause for 30 seconds or so to see if any hands pop up on electronic hands or physical hands from those who are on camera. And nothing is appearing, so I think thank you very much for that, Mr. Mazire. Do you have any other legal advice for us before we retire?
No, nothing from me, thank you, Chair.
Thanks very much. Ms Johnson, anything from the licensing point of view that you need to raise for us before we finish?
Nothing from me, Chair.
And Dan, anything